Inspection or revocation of VIP Communications Limited, Liquidation, and negative the Home Department.
Lord Richards will explain the decision of the Court.
The use of wireless communications equipment has been subject to statutory regulation since shortly after its invention in the 1890s. From the passing of the Wireless Telegraphy Act 1904 until 2003, the use of such equipment was subject to control by the government. It was an offence to install or use wireless communications equipment without a licence granted by the relevant government minister, unless it fell within a category of equipment which the minister had exempted from the need for an individual licence. The use of communications equipment may give rise to well-founded concerns on matters of vital national interest, such as national security, public safety, public health and international relations. The minister could take account of such concerns when deciding whether to grant licences or make exempting regulations. The Communications Act 2003 made very significant changes to the regulatory regime. In particular, the great majority of the minister's functions were transferred to the Office of Communications, Ofcom, a newly created independent regulator with its own statutory duties and powers. In relation to national security and a small number of other vital national interests, the 2003 Act provided for the Secretary of State to have power to direct Ofcom as regards the exercise of its regulatory functions. Section 5(2) of that Act provides that Ofcom is under a duty to carry out its functions in accordance with such directions. Under Section 8 of the Wireless Telegraphy Act 2006, Ofcom is under a duty to exempt categories of communications equipment if it is satisfied that a number of technical and other specified conditions are met. Those conditions do not include national security and the other matters listed in Section 5 of the 2003 Act, for which the Secretary of State retains sole responsibility. By their nature, they are not matters within the competence of a regulator such as Ofcom. In 2017, Ofcom published a proposal to make a regulation exempting from the licensing requirements a type of equipment known as commercial multi-user GSM gateway apparatus. The use of this type of equipment masks the number and locations from which calls routed through the equipment are made. The Secretary of State considered that the unlicensed use of this type of equipment raised concerns on grounds of national security and public safety, a judgment which is not challenged in these proceedings. Accordingly, the Secretary of State issued a direction to Ofcom that it should not make the proposed exemption regulations. In judicial review proceedings, the direction was challenged by VIP Communications Limited on the grounds that the Secretary of State did not have power to issue a direction that sought to prohibit Ofcom from carrying out its duty to issue an exempting direction regulation when it was satisfied that all the conditions in Section 8 of the 2006 Act were met. The challenge succeeded at first instance, and the direction was quashed. The Court of Appeal dismissed the Secretary of State's appeal. The Secretary of State appealed to this Court. In its judgment on the appeal, this Court reviews the development of the applicable legislation and the clear division of responsibility between Ofcom and the Secretary of State. These form the context and identify the purposes against which the provisions in question must be construed. The courts below had based their decisions primarily on two grounds. First, it was said that the wording of Section 5(2) of the 2003 Act did not permit the Secretary of State to direct Ofcom not to issue a regulation, because that could not be said to be a direction as to how Ofcom should carry out its functions. Second, it was said that there is a general principle of statutory construction that a power cannot be conferred to direct a person not to comply with a statutory duty without clear words to that effect, and no such clear words were to be found in the relevant provision. For the reasons given in its judgment, this Court rejects both these grounds and concludes that on the true construction of Section 5 of the 2003 Act, having regard to its context and purpose, the Secretary of State was entitled to issue the challenged direction, and that Ofcom was obliged to comply with it. Accordingly, the Court allows the Secretary of State's appeal and dismisses the claim for judicial review.
The Court will now adjourn.